Welcome everyone. If we haven't met before, my name is Stephanie and I'm an articling student at Russell Alexander Collaborative Family Lawyers. We want to thank all of you very much for joining us today for Family Law Now Live's presentation on Divorce and Property Sharing 201, Advanced Equalization Topics. In this 1-hour presentation, Bill, Nafisa, and Carolyn will be discussing advanced topics in divorce property sharing, covering the following topics that I will display on your screen now. So please do keep in mind the content of this webinar is to provide you with general information and is not to be considered legal advice. For those of you in the legal community, kindly note that this program has been accredited by the Law Society of Ontario and contains 1 hour of professionalism content. Now it's my pleasure to present our hosts today, Carolyn Warner, Nafisa Nazarali, and Bill Rogers. So Carolyn is a fully trained collaborative family lawyer who has a knack for developing creative resolutions unique to each client situation. Carolyn has been practicing family law exclusively for over 8 years since her call to the bar in 2011. She is committed to providing her clients with empathy and sound advice and prides herself on approaching all cases with an analytical and tenacious mindset. Nafisa is a senior managing associate lawyer at her firm. She is collaboratively trained and has been practicing exclusively in all areas of family law for over 10 years, with the best interests of children as a primary focus when providing legal advice and strategy for clients. She uses her skills as a collaborative lawyer to find creative ways of achieving positive results for her clients. And last but not least, Bill, he's a managing associate lawyer at our firm. His courtroom experience includes numerous motions, several full-blown trials, and he also had the privilege of winning a major family law victory at the Ontario Court of Appeal in 2014, which prevented the imposition of a proposed 2-year deadline on property claims by common law spouses. When he's not practicing law, he loves spending time playing music with his band, Soul Custody. And for all you legal professionals, it was named before the changes to terminology.
Yeah, Steph, I've had to rename the band Soul Decision Making Responsibility. And now we don't get any gigs because no one likes the name.
It's a mouthful.
All right. So now that you know a little bit more about our team and what's on the agenda for today, I'm going to pass things over to Bill to start the presentation. Take it away, Bill.
Thanks, Steph. It's great to have Nafisa and Carolyn here. My colleagues, they're both excellent lawyers and very knowledgeable. And I think, are we starting off with a poll, Steph? Or yeah, there you go. So we just kind of want to know who's out there. So please tell us a little bit about yourself. And there it is. We usually have a lot of legal professionals, but I'm not sure today. And while we're waiting for the answer, Nafisa, did you want to start in on talking about an overview of what's on the agenda?
So basically, these are topics that we have covered in the past. And so our agenda for today is actually an advanced version, but these are all topics that we have covered in the past. So if you feel like the discussion topics of today are kind of above your level of learning, then definitely go back to this Divorce and Property 101 agenda. And this provides you with a bit of an understanding of what we have covered. So to continue on with that, calculating and sharing family property. So what are date of marriage assets, date of separation assets, deductions, exclusions, personal injury awards, inheritances. I'm talking a little bit about the home, having more than one matrimonial home, exclusive possession of the home. What happens when the home is not the home on the date of marriage. And then we went into special considerations. So pensions, sick days, stock options, notional disposition costs, lottery winnings, and then onus, equalization, and the limitation period. So the Divorce and Property Sharing 101 was extremely thorough, and we're going to take you a little bit further today.
Thanks, Nafisa. Here's the poll. Oh, a law professional. Excellent. The 73% of the audience is a law professional. There's some other professionals in other areas. We've got 10% of people who are actually going through a separation or divorce. My condolences to you, but you will get through. They've got some law students and 1% others. So very strong on the legal professionals, so I'm gonna have to make sure everything I say is accurate. So that means I'll be signing off now. And just kidding. So Carolyn, how would you like to start by? This is a really large question, and I'll just read it. How do you calculate family property?
Let's just talk a little bit about what family property is. So when we're looking at the division of net family property, what we're really trying to do is calculate and establish how much money is owing to each spouse legally if there's a dissolution of a marriage. And what we call that is we refer to it as the equalization of net family property. So under Section 5 in the Family Law Act, we figure out how to determine one's net family property, and that is doing a calculation where we look at the basic premises is looking at the assets and liabilities of the parties on the date of marriage, on the date of separation as well. So we calculate their asset position on the date of separation. That's typically our first step. And then what we do is we look at any legally permitted exclusions. So exclusions could be things like inheritance, it could be gifts, or it could be items that both people have agreed to exclude from the division of property. And then the next step would be to look at each party's net worth by subtracting the liabilities. Then we also look at what their net worth was on the date of marriage, and that would be also be subtracted from their net worth from the date of separation. So the viewpoint is that the party that has the higher net worth would have to make a payment to the other party with the lower net worth to equalize them. It's a calculation of 1/2 the difference. This is just the basic formula, and we'll get into it a little bit later. There are some circumstances under law where there might be an unequal division of the net family property, but we'll touch upon that a little bit later as well today.
Thanks, Carolyn. And I think the key is that a lot of clients have a hard time wrapping their mind around, but it's you end up being most people's net worth increases during a marriage, and the equalization makes it so they're both up by the same amount, which is what you just explained. And I think we have another. Oh, this is my favorite poll question. How many matrimonial homes can you have?
I think we should put it out there. We can't answer.
It's a trick question. Now, the test for what counts as a matrimonial home, and you can have more than one, you can. The question is it ordinarily occupied by the couple? And that is the big test. Usually it's a cottage, some kind of vacation property. And I'm just going to wait till the poll results come back before I go into a little comment I have. There we go. Okay. So we've got a lot of people saying 1, and that's we've got some saying 2. Unspecified is probably the closest answer, because you can have more than 1. And again, usually it's a cottage. But I did a case law search, and I found a case where there were 4. The case is called Bassam, Bassam versus Bassam. It goes back to 1982. There were 4 matrimonial homes in that case. There were 2 condominiums in Florida and 2 cottages in Ontario. And the facts of that case, they were all ordinarily occupied. But that's not a maximum. Like Elon Musk, I'll bet he has like 50. And the question is it ordinarily occupied? Well, yeah, I go to Paris once a year. Okay, that's for you, that's ordinary. Anyway, so that's how that works. Now we've got, how do you deal with the matrimonial home? There's certain rules, special rules. Nafisa, how do you deal with the matrimonial home?
Yeah, so back to your comment though, Bill, in order to be a matrimonial home, you have to be married. So I want to just highlight that.
There is that, yes. Yeah.
So just so not to confuse.
Minor detail.
Minor detail. So the definition of a matrimonial home can actually be found in Section 18 of our Family Law Act. And you've done a really good job of describing it. So essentially what it says is that a matrimonial home is every property in which a person has an interest, and that is, or if the spouse is separated, was at the time of separation ordinarily occupied by the person and his or her spouse at their as their family residence. So I think the highlighted part for me in this definition is at the time of separation, because if you lived in a home and you don't have it anymore, then it's not going to be considered a matrimonial home. It actually shifts into a date of marriage deduction if you were married at that time. So that's a really important distinction with this definition. Other relevant considerations when we're looking at a matrimonial home is that question of ownership of shares. So if you own a share or an interest in a share of a corporation that entitles the owner to occupy a housing unit owned by that corporation, this is deemed an interest. So for example, in a situation where a corporation is an alter ego of a spouse, and that spouse is using that corporation to try to defeat the other spouse's legitimate claim, that spouse will not be able to hide behind that corporate veil. So we're also looking at an interest. And then the other aspect to really look into is, residence in a farmland. So the full definition has all of these elements. So if a property includes a matrimonial home, it is normally used for a purpose other than residential, then the matrimonial home is only the part of the property that may reasonably be regarded as necessary to the use and enjoyment of the residents. So when a property is qualified as a matrimonial home, like I said before, you cannot claim this as a date of marriage deduction on the property. So this is something that I always advise clients that come to me that are considering a marriage contract to really consider, is this a home that you own now when you get married? Is this a home that you're going to own when you're married? And do you want to make sure that you're protecting yourself by having a marriage contract that says that you're going to be able to get either a date of marriage deduction for that home, or in the alternative, completely take that out of equalization and contract out of this particular aspect of our legislation. So in determining whether a property such as a cottage, for example, is a matrimonial home, you have to ask really two questions. The first one is the property ordinarily used by the spouses? And the question, if you say yes to that, then is it used as a family residence? And if those two questions are answered in the affirmative, then you're looking at potentially having another matrimonial home. So as you said, there may be quite a few. With matrimonial homes, one thing to remember is that neither party can exclude the other from a matrimonial home unless you have an order of the court, an order for exclusive possession. So you cannot lock another spouse out of the matrimonial, irrespective of whether the other spouse is or is not on title. Everyone has the right to remain there unless there is a court order that says otherwise. Lots to say right there.
Yeah, thanks, Nafisa. That was an excellent summary of the law. And now I'm ready for poll number 3, which very much ties in. There you go. Our family cottage is passed down from generation to generation, excluded as an inheritance. We've got a poll here. That's a sticky question. I think you'd have to basically, well, I'm going to wait for a second, and then Nafisa or Carolyn or both can address, once we get the answers in, can address that, because that happens a lot. So we'll just wait for that poll to come. Oh, here we go. Okay, so it depends is the biggest answer. I've got some other answers as well. It depends is the correct answer. And would either Carolyn or Nafisa care to explain that?
Not really.
I'm not going to either. Are you going to?
We have to.
Well,
I think we have a really smart group, and I think, yeah, it depends. And it really does. I think it actually, the third one here, the wording of the will ultimately will be important because it will indicate whether or not it's excluded, and it will depend.
Yeah. I think there have been cases where a cottage that is a family heirloom has been divided, and the person is not happy about it. So it can happen. It does depend on the fact. Now let's go to slide 13. And Carolyn, this is exactly an offshoot of what we were talking about. How can you protect your inheritance from your spouse?
Yeah, no, so that's good. So the question here is really, when you look at it as like from time to time, someone may receive an inheritance from a loved one, and chances are if it's inherited, it's personally to you and not necessarily your spouse. So there are some distinctions that I think we should talk about, is whether or not you receive an inheritance while you're married, or whether or not you receive an inheritance prior to marriage. So the key thing is, I'll talk about dealing with prior to marriage first. So if you receive inheritance prior to marriage, it's very important to obviously document all the information. Generally, under the Act, the virtue of the Act, any inheritance is excluded. If you do receive it prior to marriage, it's important to keep a copy of the will and any letters or anything like that that you get from the estate trustee confirming what you've received. It's also recommended that you open up a separate account in your sole name that just deals with the inheritance. Always keep proof of the amount that's deposited into the inheritance account, and also keep proof of the running balance of the inheritance on the date of marriage. Because if you've drawn down on the inheritance prior to get married, it would only be the outstanding balance that still remains on the date of marriage that you would be entitled to keep as an exclusion. If you've invested that money later on down or into like other assets, obviously keep proof of transfers or documentations. In the will, it would also indicate whether or not any income earned from the inheritance would also be excluded. And if so, you'd want to keep copies of your inheritance interest earning statements. It's important to keep in mind that if you take the money from an inheritance and you decide to invest that money into a home that you live into with your spouse, that technically you would lose your inheritance capabilities. So in that instance, we usually would consider that you consider looking into drafting a marriage contract. It's also not recommended that you use the inheritance to pay off any joint debt, or if you if you're going to deplete the inheritance, maybe wait to do it until after the date of marriage. And so these sort of tips do go in line again if you do receive an inheritance during the marriage. Same idea is just to document. The key thing is if you do receive an inheritance during the marriage, it's very important to have that held into a separate account. Sometimes people will put it into a joint account, or they'll use the money to, pay down a joint debt, for example, a mortgage, or they might use the money to purchase a joint property, a cottage, something like that. That would be risking your exclusion of the inheritance. So a lot of the time,
I think the key is the don't intermingle.
Yeah,
Keep it separate.
exactly. Keep it separate. And so if you are going to intermingle, then I think the key would be to consider doing like a marriage contract. People sometimes forget that you can do a marriage contract after you've got married. So we just call that, a post-marriage contract or post-nuptial agreement. It's still capable of dealing with that. And it could just particularly deal with how you've maybe used inheritance during the marriage or prior to the marriage, in a sense that you want to just protect that money in the event that there's a breakdown. It's just like an insurance document. And then if you're not married, then there's always some consideration to do a cohabitation agreement. Bottom line is whenever we get these files, I know Nafisa and Bill will attest, we're always saying, show me the money and show me the paper trail. So it's all about document, and being able to trace the monies going where it has gone, because that is going to be the key to any inheritance matter, is always tracing the money and showing where it has gone.
Thanks, Carolyn. And it's as you just explained, the easiest is if you get the inheritance before marriage. That's just a simple deduction. You don't have to worry. But if you get it during the marriage, all that stuff you talked about is super important. Now, the next slide, number 14. Family trusts. Now, this is something that generally it's the wealthier clientele where this issue comes in. And Nafisa, Can you give us a rundown of some of the issues on family trusts?
Yeah, absolutely. There are a lot of questions that are coming in about the matrimonial home that I just like to address very quickly before I turn to family trust. So a lot of questions are coming in about excluding the matrimonial home from the net family property statement through marriage contract. So absolutely, you can do this. So if you have a matrimonial home that you'd like excluded, you don't want to share in it, get yourself a marriage contract to exclude that. And then the other question, which I thought was interesting, what if a cottage passes down, could also be considered a matrimonial home? I assume it would be excluded. Yes. So if you look at the definition of section 4.2 of the Family Law Act, it says that an exclusion is any property other than a matrimonial home. So that the other than a matrimonial home would answer that question. And so if it is considered a matrimonial home, you can't exclude it. So just a few questions there answered. But let's turn to family trusts. So this was a very difficult topic for me to do, but it is complex. So let's get right into it. So when you look at family trust, the first point where you have to start is Section 4 of the Family Law Act, which has our definition of property. So in Section 4, it says that property is defined as any interest, present or future, vested or contingent in real or personal property. So this definition is very broad, but it does capture the family trust issue. So an interest in a trust may be an interest in capital of a trust. It can be an interest in income from the trust, or an interest in both capital and the income of the trust. So when we're looking at family trust, I think it's really important to look at timing to see whether it's included, excluded, or deducted in equalization. And those are very different things. So when you're looking at the timing, where a trust interest is established prior to marriage, the value of that interest is seen as a date of marriage deduction. So right at the start, you can deduct that as a date of marriage deduction. Where a trust is established during the marriage, the value of the interest is excluded, assuming that it follows it qualifies, I guess is the right word, as an exclusion. And I will again point you to Section 4.2 of the Family Law Act, because it's, the wording is so important. Whenever I have questions of equalization, I always go back to the wording, because over time you forget what that section actually says. So Section 4.2 of the Family Law Act, it says that property other than a matrimonial home that was acquired by gift or inheritance from a third party after the date of marriage is excluded. So that's where the timing piece becomes really important, because it needs to happen after the date of marriage for it to be excluded. So when there is a distribution from a trust where the party's interest is established prior to marriage, and then what happens is you distribute the amounts during the marriage, then you'll still include it, because you're looking at 2 points in time: the date of marriage, the date of separation. And so you may have to share in the value of that. So that could be included. So again, when you have a family trust, it's important to kind of dissect it. And it's all factually based, right? So is it capital? Is it income? When was it gifted? Those are all very important sort of determining facts that you'll need in order to determine what you do with that family trust. So courts in Ontario have found that the definition of property does include trusts, which are contingent or vested. In terms of how the courts have valued these trusts, they've used different approaches. So again, you go back to the legislation, and then you also look at what is the value. So now you know that you have a family trust. The amount, how is it valued? So what courts have done, they've done 3 different ways of valuing this. They've done if and when approaches. So an if and when approach is if and when a recipient will receive that payment from the trust in the future, then what the courts have said is that they will be considered to be holding a portion of that payment received in trust in favor of the non-beneficiary spouse. The other way that they've they quantified it is a notional, it's called a notional pro rata distribution. So this approach will take the value of the trust on the valuation date, divided by the number of beneficiaries that are assigned to it, and then provide a notional equal share of the property and include that in the equalization. And so again, it's really important to examine the actual facts of your case. What is the purpose? What is the history? And the third approach is that it's looking at the facts of that particular case, including the way and the reason the trust was created, how it has been operated, and then using this assessment, there is a bit of flexibility of how the court will consider that family trust in your particular case. So they've used that one the most in my review of the legislation around this area, but very complex area. I think for me, the key is just to dissect it into smaller pieces, look at timing, look at reason, and kind of make your arguments based on those facts.
Thanks, Nafisa. That was once again an excellent overview, and definitely a very fact-specific area.
Yeah.
And it's a lot of dissection, as you pointed out, to find out exactly what's going on. Super important. We're going to move on to poll number 4. Pensions, the dreaded pensions. Question is, does every type of pension require an official valuation? So we call it yes, no, depends. All those answers. So we'll let that percolate for a second. Because there are these different types of pensions, defined benefit, defined contribution, they're treated differently. And before we talk about it, I'm just going to wait till the poll comes back. And here we go. Okay, so we've got various opinions here. It's not quite clear what it is. So let's turn to Nafisa once again. Sorry to overburden you, but can you talk about equalizing pensions and the defined benefit? Defined?
I can. So that question is actually no. So you don't really necessarily need an official evaluation. Yeah. It's always good to get one done, but it also depends. So part of my topic is really, what defined benefits and defined contributions. What is the difference? So whenever I have a client who has a pension, that's kind of the first question that I ask, is that, is it a defined a benefit pension? Is it a defined contribution pension? Because based on the answer to that question, I will kind of have a general idea of what I need to do with that pension and how I need to value it for the purposes of equalization. So a defined benefit plan, it actually provides a specified payment amount in retirement. These plans provide eligible employees guaranteed income for life when they retire, and employers guarantee a specific retirement benefit amount for each participant that is based on several factors, such as the employee's salary and years of service. So when you have a defined benefit plan, that's when we have to obtain a family law value for the purposes of equalization. So you fill out the pension forms, they're submitted to the plan administrator, and the plan administrator provides us with a family law value for that pension. I think it's important to remember, though, that whatever the value you get, so let's say you fill out the form, the pension plan administrator provides a value. That value, when you're inputting it into your net family property statement, it always has to be there has to be a notional disposition tax deducted from that amount, because when you retire, when you go out to pull out that money, you're going to be taxed on it. So it's not fair for you to have to put the full amount without having that contingent liability in your liability section of your financial statement. A defined contribution, on the other hand, it's a plan that allows employees and employers, if they choose, to contribute and invest funds over time to save for retirement. So with a defined contribution plan, you can obtain a statement, and in that statement, it provides the value that you can then include in your client's financial statement. And you do not necessarily have to obtain a formal pension valuation for a defined contribution pension. When I have a client who has a pension, the first question I ask is defined benefit, defined contribution. The second question that I ask is this a pension that is in pay or is it not in pay? And the reason that I ask that is because when a pension is in pay, you do have to factor in consideration for survivor benefits, and those survivor benefits are actually attributed to the other spouse in their side of the ledger when you're doing your equalization. And then the other consideration is if a pension is in pay, you can't, when you're looking at ways to pay out an equalization payment, you can't do a lump sum of the pension when it's in pay. So that's another important consideration when there is a pension in pay.
You can't do a lump sum from the pension, right? But you can get a lump sum else if you have other assets.
Exactly. So
Yeah,
if you have,
okay.
a matrimonial home, or if you have a cottage, or if you have other assets, then you can absolutely do a lump sum from those assets, but you can't lump sum it out from the pension to pay out.
Right. Yeah, it's a sticky topic, and thank you for that. Now we're going to move on to slide 17 and something very, very modern, the cryptocurrency. Now, Carolyn, what's up with cryptocurrency?
Yeah, so cryptocurrency, I think for a lot of people, it's like a new topic. And there's not necessarily a lot of knowledge about the topic. So I'm hoping to go through that with you today. The hardest thing I think with cryptocurrency is trying to recognize whether or not it exists. I think a lot of people think when they hear cryptocurrency that their spouse is going to use it to try and hide assets and, hide ways outside of the equalization. The fact is that cryptocurrency or other assets, like you hear about NFTs as well now, those are still considered assets that need to be valued and need to be accounted for in the equalization calculation and put on the appropriate person's side of the NFP ledger. So the thing though with a lot of crypto enthusiasts is that they usually talk about it. You probably would have heard them mentioning it before or something like that they've had some kind of an interest or they purchase some cryptocurrency, so they usually do a talk about it. The thing that's important with crypto is just to realize that it's just an algorithm really for assigned unit of currency. So the cryptocurrency unit is referred to as the coin, and then the database that holds the coin is referred to as the blockchain. And then there are people where you can receive cryptocurrency just for selling and mining the blockchains. So when it comes to cryptocurrency, if you've got a client that has it, or if you're a party that has it, the most important thing is just to be honest within the proceeding. The biggest factor of this is to disclose, to provide disclosure. And so in terms of the cryptocurrency, like there is in Canada, like you could bring a motion, or you could bring something like that if you're in a family court proceeding where you could be legally required to disclose or share all that information of assets that you have, or to obtain it from a spouse if you think that they don't have it. The thing will be with that is to finding the key, because the key is what holds the chain for all the information for your chain. So that's why it's the reason why cryptocurrency is so questionable, is because it's hard to track. It can be problematic because if you don't know the private key, or if it's lost or anything like that, it could technically be impossible. It is impossible to access the cryptocurrency and trade it back to an individual during the process. In terms of if you find out that a spouse has the cryptocurrency, then the key thing would be to obtain the keychain. And if you are needing more assistance with finding the disclosure of the crypto assets, then you always have the ability to go back to family court if necessary in order to get an order for that disclosure.
Thanks, Carolyn. It's such a, I still don't really understand it. Obviously you do. If I ever get any, I'll call you.
One more point though.
Oh, sorry, I cut you off.
Yeah, because it's so volatile. I think what has happened with the cryptocurrency is that usually on the when you look at your equalization, you're looking at what would be the value of the cryptocurrency on the date of separation. You hear things like it goes up 1,000% or it's down like 98% or something like that. So technically, like under the law, you're supposed to do the value of the asset on the date of separation. Sometimes in separations, with cryptocurrency, they might be more open to doing a current day value assessment of the cryptocurrency and only do a division as at the current time as when it's being traded because of the volatility because of it. And so if you transfer it, cryptocurrency that could be another issue, dealing with transferring it. So some cryptocurrency holders, like you can do account to account transferring. Some of it may be required for you to cash it in and transfer it from the cash that is when it's cashed in. I think some of them, depending on what cryptocurrency you use, like some of them have like actual ATMs. I know there's a few big name ones that you hear like downtown Toronto that you would be able to do it that way.
Thanks, Carolyn. I think we should have a new rule. It's not the date of separation, it's the minute of separation. You get the exact value, because you know what? Our relationship was over at 3:59 p.m. No, it wasn't. I still had hope until 4. Yeah, that's going to be the next big issue. Let us talk about, we got slide 18. Thanks again, Carolyn. That's amazing that you know that stuff. Slide 18, tax and other considerations. Nafisa touched on this a bit already. Notional disposition costs, capital gains, that kind of stuff. Nafisa, what's this about?
Yeah, before I go to that, I just want to answer a few more questions. These are such great questions. I don't want to pass up on them. So
yeah, thanks for sending the questions in. I'm having a hard time. I would be answering them, but I'm having technical difficulties. So thank you, Nafisa, for covering.
Yeah, no. I mean, as much as I love tax and other considerations, these are really great questions.
Yeah, good idea. Let's move to the questions.
So there's one about, what about inheritance that is not money, like objects? So again, it's the value, right? So if you have something that you've inherited and you look at what the value of that property is, one important thing that I find a lot of people miss out on is that they put a huge inheritance in their financial statements, $50,000 car, for example, that's not in existence. So make sure that when you're excluding an inheritance, you've got to be able to track it back to your financial statements, find it there, and then exclude it. If it's not something that's in existence at the time that you're filling out your financial statement, it's not an exclusion. You've lost it. Like it doesn't exist. So that's an important distinction that I see often happening in financial statements. And then when I ask the person to track it, it's no longer in existence. So then I say, okay, well, then it's not an inheritance. Another question that came up is just to clarify. Someone asked, if property is inherited before marriage, it can be deducted from a party's NFP, but not excluded. That is correct. So it would be a date of marriage deduction if it was acquired prior to the marriage. So you're correct in that.
Yep.
Okay, so let's move on to tax and other considerations, notional disposition costs and capital gains. So notional disposition costs is really just a fancy way of saying financial consequences for cashing in an asset. So whenever you say, notional disposition costs, it sounds very complicated, but we're just looking at, okay, what are the financial consequences of cashing in, RSPs, pensions, also commissions for real estate agents, taxes that are owing out of the sale of a land or stocks, for example. So when you're filling out your financial statements, and I often, I look back and there are times where I forget these because when you're filling out your financial statement, you're putting that in a different section. So you're doing your assets, and then in the liability section is where you're referencing the notional disposition taxes or costs associated with the asset. So I have found actually a lot of lawyers, what they're doing is they're actually putting the notional disposition tax in the asset portion in brackets and subtracting it right away. I don't think there's a right or wrong answer to that. It is supposed to be in the debt and liability section, but in order to make sure you're capturing it all, I feel like for me, that makes more sense. You have the asset and you automatically just deduct the notional disposition tax because you're not then going to miss it.
Problem is you can't do that on the cloud and DivorceMate anymore.
That is true.
They wrecked it.
That is true. So hopefully they will allow us to do that, because I find that when you're connecting the assets and the disposition taxes, you're less likely to miss one if they're right in the section together. So I guess the basic concept is, for example, if you have an RSP, it's worth $100,000. You include the asset at $100,000 under the RSP side, asset side of the financial statement. But then you'll go down when you're filling out the liability, you're going to put a line in, you're going to say notional disposition tax, and you're going to reduce that RSP by a notional disposition tax. Usually I see the tax rates between 15%, 25%. It really depends on the income you're going to have at retirement. So it's a guesstimate at best. What I do say is that if you do have a large RSP or a large, pension asset, get someone to value it. It costs a couple $100. You get someone to give you a more exact number for what is the percentage that you're going to use, because it can actually make quite a big difference in larger assets. If you're using a difference of, between 15% and 20%, it makes a huge difference in the amount for equalization. So just for that certainty, I would say with bigger assets, it's, get someone to help you out with the percentage.
Thanks, Nafisa. That's we're
we
kind of
running
running low on. We're running a little.
there's
short
so
on
much
time.
to say. There's so much to say. Okay,
Did I just cut you off on your most amazing statement? Okay, over to you.
They're all amazing. They're
I know,
all
that's
amazing.
true.
But
I'm
okay,
sorry.
just remember, capital gains is also very important. It gets missed a lot. So you can find online how to calculate capital gains. Again, you can go to an accountant. They can help you out. And also, another thing I see often happening is people forgetting to deduct notional disposition taxes on date of marriage assets. So just make sure if you have an RSP on the date of marriage, you're having a deduction on that asset as well in the liability section. All right, now I'm done.
Well, I know what my tax rate's going to be when I retire. I've already got my basement apartment picked out. It's going to be low. Okay, let's go. Business valuations. Now, this is a very interesting topic. We've got a poll. When is a business valuation required? Always, never, depends. Only if it's incorporated, if there's multiple shareholders. So let's let that happen. And while we're doing that, I think we can actually, Nafisa, once again, it's you who's going to be talking.
No, it's me again.
I want you to discuss. I want you to discuss hot tubbing in depth. Have you heard that one?
I have.
Yeah. That's really the big issue of today. Is hot tubbing.
Yeah. So hot tubbing is when you have two different experts and they are getting together and talking about why they're different valuations, why they have different values. And sometimes it can be, millions of dollars in differences. And it's just the techniques that they've used or the methodology that these business valuators have used to value business can really result in huge discrepancies between values. So what judges often say is, have your experts hot tub that topic, and so you get the experts together, they have a discussion, and sometimes they come up with a middle ground as to what the value of that business is. So that's. But
they never actually use a hot tub, no. And I think they should. But that's just
help. It may help with
only in court, only in actual court. Oh, here we go. Okay, so. The answer depends on what type of business. Always, I can totally see why you'd say that, because usually it's an issue. But apparently, technically, it depends on the type of business. Can you maybe continue your elucidation, Nafisa?
This is not my topic, Bill.
Is it me? Wait a second. I can talk about it. I prepared for this. Do you want me to talk about it? Okay.
Yeah.
Okay. Well, one thing I'd like to point out is they changed the rules right after the pandemic started, and now expert reports are due before the settlement conference. Everyone knew that. So I guess that's a very good way of trying to reduce the amount of trials. And they did the same thing in the rules of civil procedure. In May of 2019, it depends on the type of business. I mean, you do a cost benefit analysis. I mean, if the rule of thumb is if the business valuation costs more than the business, probably not a good idea to do it. I had a quote on a case I've got right now. The valuation, the price tag on the valuation for the business was $50,000. So we're talking about a significant expenditure. Nafisa, I know you had a case where the gentleman was in a trade and he had a van full of tools, but no inventory, and it was really just him. And, you know, what do you do there? It's probably not worth spending money. And yes, there's going to be, on day 2, there's going to be an in-depth discussion about business valuations at 3:15 with Melanie Russell, Ankit Varma, and Russ. So that's tomorrow. So I'll just kind of talk superficially a little bit more about it. Why do you get experts having different views? And that's when they go in the hot tub. And I think the reason is, well, one works for one side, one works for the other. And even though they have to sign that thing now that says they're neutral and nonpartisan, which they are, but you know what? There's going to be different hypothetical assumptions a lot of times. And if you're working for someone, you're going to want to pick the ones that are in line with your client's position. So that, I think that's the reason they do that. And a business valuation also will not only talk about the value of the business, it'll also give an estimate of the income from that business. So you've got really those two elements. And the general rule is, if it's your asset, you have to pay to have it valued. Now, if you're in a collaborative process, it can be different. You can jointly choose one valuator. That's a really good way to go. But if you're not in collaborative, you're the one who has to pay if it's your business. Sometimes there's talk about goodwill, and there's personal goodwill and commercial goodwill. Now, personal goodwill, it does not have a value. It's not worth anything. I had a case where the gentleman was a motivational speaker. That was his business. And he was it was a company, but he was the only person in that company. He was the company. And he was the motivational speaker. So there's no goodwill there. You can't sell that. I don't even think you could sell the business at all because it's just him. So that's a good example of that's personal goodwill. It's not worth anything because if he wasn't there, no one would buy it. Double dipping is an issue that comes up sometimes. It's kind of like, if you've equalized the value of the business, are you going to use the income from that business for spousal support? It's iffy. You've got to really, it's very fact dependent on how that comes down. And outside of that, I think that's pretty much all I wanted to say about business valuations at this point. Just moving on then to slide 22. And this is back to Carolyn. Unequal division. You can have an unequal division if doing an equal division would shock the conscience of the court. Going back to Lord Denning and Lloyd's Bank and Bundy, which established the doctrine of unconscionability. Carolyn, when is it appropriate to have an unequal division?
Thanks, Phil. Lord Denning was my favorite in law school.
Yeah.
The
case begins with poor Mr. Bundy.
Yeah.
I wonder how this is going to come out.
Yeah. So the word unconscionable, like you said, Bill, is shocking to the court. And, you know, people try and use the words like unfair or unjust or anything like that. And that's not the standard. It is unconscionable. And the definition itself, it's hard to define when that would apply, but I'll give you some scenarios when an unequal division has been ordered in the past, and we can run through that. So when you're looking for an unequal division, you can be guided by that under Section 5.6 in the Family Law Act. And that would be a circumstance when it's appropriate for the court for a spouse to be awarded more or less than half the difference between the parties' net family properties. Because it would be unconscionable to do so. So one scenario would be if a spouse failed to disclose to the other spouse assets or liabilities existing on the date of marriage. There is one case where, you know, $300,000 of debt wasn't disclosed on the date of marriage. Another example would be if there's liabilities that were claimed during the marriage that were reckless or incurred in bad faith. So this would be when a spouse on their date of separation column, they have significant amount of debt, and you would say that it was reckless or bad faith. I find this one is a hard one. A lot of the time, you know, clients want to erase this one, but it's not just that, you know, they racked up debt and, you know, maybe they were living beyond their means. Sometimes that is an often one where they're using, you know, taken from Peter to pay Paul, but it would be a different scenario if they were doing it recklessly or bad faith.
A lot of times it's like gambling debts.
Yes.
They were in Vegas. No one knew he was down there for 3 weeks, gambling everything away.
Yeah, that one. Or I have a lot of people that try to say something like, oh, well, they were, there was infidelity and, you know, they were using the funds to fund this extramarital affair. So that's another one that comes up quite a bit. And you have to be very careful with that if you do want to make that argument. And it does, you know, require going through the disclosure and looking through all the statements. Another part would be if there's unequal would be if you have a marriage that's less than 5 years, typically then there would be an unequal division.
That's so weird though. Why is that shocking? Like everything else.
Yeah, I think they expect.
I guess it is. Okay, I'm shocked.
Yeah. So with the less than 5 year rule, there's no real science. Like a lot of the times when you're in court, you have judges that sort of apply this 20% rule. So they say, you know, you'd get 20% for each year of marriage less than 5 as part of the equalization. So you do the equalization calculation. If it's a 1 year marriage, you get 20% of the equalization payment. 2 years, 40%, and then you go up until it would be a full amount if you've reached at least 5 years of marriage. Another example would be if there's been a large amount of debt. So that could be like if people were, you know, living beyond their means or lifestyle, and one spouse ended up with a lot more debt on their side of the NFP, and it may have been for the benefit of the family. It may make sense to have an adjustment in that sense. And the whole point of doing this unequal division is just to look at the full, you know, responsibilities and the dynamic of the relationship throughout, and finding a way to say like maybe an unequal division would not make sense in those consideration. Yeah. And I know we're running out of time,
Thanks,
so I had some cases,
thanks, Carolyn.
over them.
I'm wondering, we only have 5 minutes left. I'm wondering if we should just jump to some Q&A or do we want to? We just skipped the last topic, which was supersized collaborative teams.
I think we can just quickly say, I mean, so sometimes with collaborative team, you can bring on, you know, other professionals to assist, corporate business valuations, tax experts, estate planning experts. So these are all, that's a benefit of having the collaborative team, is that if you require additional expertise, you bring them onto a team. So I can just give an example for a case that I had. I had a pension. It was akin to a CPP in Norway, and I needed to know what is the value of this pension that someone has contributed to in Norway. I hired an expert, provided me with an actual expert report on what the value of that Norway pension would be, and that was what we equalized. So there's lots of opportunity to be very creative. So I think that will kind of cover that slide.
And just to add to the Nafisa, like we say CP teams, but I'm often like, even in my files that are not collaborative, you can draw on those same professionals to assist. So I do find that that's helpful as well.
Yeah, I agree, Carolyn.
It's a great way to go, and it can save a lot of money. Although some people have sticker shock at the beginning, the upfront cost, still cheaper.
Yeah, I always tell my clients, you can pay, you know, between 5,000 to 8,000 for this expert, or we can go to trial and you could pay 50,000 plus, right? So it's like, you've got to make an analysis of costs. What are the cost benefits, and what is the next step if you don't resolve? And trials are atrocious in terms of the amount for each day of trial. And a lot of times, if you can resolve early with the help of an expert, that's always the best way to go. You're probably going to save yourself a ton of money by doing it that way.
Yeah. Hi, Steph.
Hi, I am back for some Q&A.
Sorry, we ran a bit long there, but yeah,
No,
let's
that's
do it.
okay. I always love these presentations because even myself, I learn so much every day. So let's just jump into a few before we run out of time. So one that came in, can property equalization be resolved after divorce? I'll open the floor.
Yeah, absolutely. So you have your limitation periods, 2 years from the date of divorce, 6 years from the date of separation. So you can definitely equalize according to those limitation periods. So yeah.
Thanks, Nafisa.
2 years though, 2-year limit.
2-year limit. Yeah.
All right, next one we have is, in common law relationships that are clearly marriages, why does equalization seem so difficult?
Well, they do it. They don't do it with an equalization. They do it with a trust claim called a joint family venture, which is basically common law equalization, but it's harder to do and it's less exact.
Yeah.
But there is a difference between being married and not. People don't think there is. There is.
Get married. You'll recognize.
You get married to get equalization.
There are
Not
other
as-
provinces. There are other provinces though that do have an equalization mechanism. So
Yep.
hopefully we're moving towards a system where common law spouses will be able to.
In BC, just live with someone for 3 years and then you get equalization.
Yeah, yeah. I think we're gonna head over that way. My view is,
Well, that'll be a crying shame. I like doing joint family ventures.
You're the worst.
All right, well, thank you so much. I just want to be mindful of everyone's time. So thank you to our panel again, and thank you everyone in the audience for taking the time to join us today. We hope you found the content helpful. And next up at 3:15, we have our last presentation of the day on common law separations, advanced topics with Russell Alexander, Michelle Mulchin, and Bill Rogers will be joining us again. Thank you so much, and we hope to see you soon.
Thank you, everyone.